My name's Howard Jacobs. I'm an attorney in Westlake Village, California, which is just outside Los Angeles. I've been practicing for about 23 years and primarily in sports for the last 11 or 12 years. Law, I just went straight through after university to law school, and then I practiced in primarily admiralty law for about 10 years and did some work for USA Triathlon. I had been a professional triathlete, so I did some work for them as outside counsel and ultimately transitioned to representing athletes. And it's just as the way it's worked out, it's mostly been representing athletes on doping cases as well as team selection disputes and some litigation matters as well. I can't remember how the initial introduction came, but I started doing various contract dispute litigation matters for them. One of the first things I did for them was actually prosecuting a doping case before the whole WADA-USADA system was set up, back when every sport had to prosecute their own athletes. And so that was my introduction to doping cases. And so then when I ultimately had the opportunity to represent an athlete before the Salt Lake Olympics, I had the experience having done one case. I've represented over 120 athletes on doping-related cases. Probably the most interesting case was the case I did actually representing the U.S. Olympic Committee growing out of the LaShawn Merritt situation involving the Osaka rule, the 6-month rule that if you were banned for more than 6 months, you couldn't go to the next Olympics after your ban ended. And so I represented the USOC on that. We challenged the rule, went to CAS against the IOC and won, which was a very interesting case and really satisfying because it, I think, helped so many athletes and clarified the rules. And it did so well in advance of the Olympics last year, which was good as well. When it started, I'd never thought it was going to be like such a huge part of my practice. Like I said, the first athlete I represented was right before the Salt Lake Olympics, and the case, at least the initial hearing, went pretty well. It got appealed. It didn't go so well at the appeal. The athlete ended up missing the Olympics, but I took the time and studied the drug tests a lot, so I read up on the science, and not that I had a real strong science background from school, but it was something that interested me. So I'd read a lot of journals and got to where I thought I understood the tests, at least at some rudimentary level. And I think I was able to quickly develop a reputation as one of the few attorneys that actually understands the science of the tests, which is a constantly evolving thing because there's always new tests coming out. And for me, it's critical if you want to do this kind of work. If you don't understand the tests, I don't think you can competently defend an athlete unless you're just never going to do a case that involves a science issue.
Which is rare.
It is rare. It's rare that you'd have a case where you wouldn't even look at the science issues, and it's hard when you take a case to know what the issues are going to be. So if you take a case thinking, well, if there's science issues, I just won't raise them, then that's bad. I think the biggest issue now is the revisions to the WADA code that are going through, and nobody's seen the third revision, but the second draft of the new WADA code had some very significant changes that are troubling to me as an athlete's attorney, and I think will result not really in what they're trying to achieve. I think you're going to see a lot of athletes get 4-year bans even where their positive tests were caused by inadvertence. If they can't prove what caused their positive, then they're going to end up with 4 years in many cases. I think that's the biggest problem. It's the biggest concern that I see. I've sued probably somewhere between 12 and 15 supplement companies. The first supplement lawsuit I did was actually for the very first athlete I represented. So this was back in 2002. And I've done a lot of them since then. Actually, in the United States, there's only one of those cases that ever went all the way through jury trial to verdict, and that was a case I handled for a swimmer, Kicker Wenzel, who got suspended for 2 years after taking a vitamin that was shown to be contaminated with a steroid. And we sued the supplement company and went to trial, like I said, and the jury gave him almost $600,000. The majority of the cases have settled since then.
But that didn't help him?
It didn't give him back his Olympic experience, or at least the opportunity. And if you talk to him, of course he'd rather that the whole thing had never happened. And similar to every athlete I've represented on those, they would rather not have that stain attached to them. I think if you're talking about for young lawyers, I mean, the most important thing is to get the best legal experience you can. It's hard to come out of law school and jump right into sports law. Like I said, it was 10 years for me, but I had a good litigation background, and I had done a lot of, I'd done trial work, I had done a lot of depositions, and I think I had good experience in litigation, so that when you get the opportunity, if you're a well-trained lawyer and you have the opportunity to move into sports, you still have to perform. And so the first thing is get the best experience you can. The second is to look for the opportunities. For me, I could not have mapped out the career that I've had, but the opportunities arose in an area that I was interested in, and I capitalized and made the best of it. And I think that there's always new opportunities, but you have to look for them and you have to recognize them kind of before everyone else does. And there's a little bit of luck. You got to be in the right place at the right time.
Was that 2?
I think that was 3 if you count the luck part.